Hello friends, today we'll talk about the offense of perjury. This offense of perjury, like which is defined in the section 340 CRPC, read with 195 CRPC, does not contain the actual definition. But whereas the Honorable Supreme Court of India, in the judgment of Kishore Bhai Gandu Bhai Petani versus State of Gujarat, has defined it. Let me read it out for you. Perjury is an obstruction of justice deliberately making false statements which are material to the case, and that too under oath, amounts to the crime of perjury. For example, somebody is making a false statement, okay, or else like he is under oath, he is giving a false affidavit, he is submitting a fabricated and fake document knowingly that it is a fake one, okay. So these are all various kinds of perjury which will be attracting a punishment up to 7 years. And normally the court of law, whichever court of law you are submitting these, like even if you submit in the police station also, that will attract the crime of perjury. This was upheld by the Honorable Supreme Court of India in Bhima Raju Prasad versus State of UP. Even if you give a false statement before the Bhima Raju Prasad versus state, represented by deputy commissioner, I guess. So this was in the year 2021, very recent one, 12th March. All right, my dear friends. So in this case, it's a landmark judgment. This was held that if you give kind of false statements and fake submissions or fake documents before the police station at the time of investigation, they shall also attract the crime of perjury. All right. And the next thing, if you are doing this perjury, if somebody is committing it in the court of law, that is in the trial courts, the opposite party normally will move an application of the perjury, and normally the court below, trial court, shall take cognizance of the offense and they'll proceed accordingly. This is the first thing. And if at all you are trying to commit the same case, the perjury, all these ingredients on the face of the high court, if you have filed a false affidavit or false fake documents, and if you are trying to defend or trying to make a case out of it in the high court or supreme court, in that scenario you are committing a perjury on the face of the honorable court, and it is additionally, it will attract the criminal contempt. All right, my dear friends, that is criminal contempt, because you are obstructing the justice, you are interfering with the dispensation of justice. All right, so additionally you are liable for 6 more months apart from 7 years. And the next unfortunate thing in this perjury is that something called audio alteram partem. It's an Italian word that means right to be heard. The right to be heard for the accused, the proposed accused, whomsoever is committing perjury, the court is not it's not your right or privilege that court has to hear your version. All right, the court will deny it, because it was upheld in the case of Pritish versus State of Maharashtra. It was way back in the year 2001. But whereas again, what happened later on in the case of Jagmohan Dalmia versus Sharad Pawar, the landmark judgment, the Honorable Apex Court has not dwelled upon the earlier binding precedents, whatever judgments it has given. So therefore, a question of law was framed to a superior bench, to a constitutional bench, and the constitutional bench has taken up this matter at a later stage, and then it has adjudicated this particular matter. All right, my dear friends, and let me appraise you about that. There is also one more fantastic judgment in the year 2012, Anju Chaudhary versus State of UP. This was also given by the Honorable Apex Court of India regarding the right to be heard. And later on in the Priyanka Srivastava and another also versus State of UP, the same contents were taken up for giving false complaints or such kind of things. And Iqbal Singh Marwa and another versus Meenakshi Marwa and another. This is also a landmark judgment of 2005. This is also on the perjury. So these all deal with right to be heard. Whether if you are accused of committing perjury, then do you really have any right to defend yourself? This the Honorable Apex Court has answered in the State of Punjab versus Jasbir Singh case, and this was the criminal appellate jurisdiction of the Honorable Supreme Court of India, and this is on perjury, and all about a right to be heard. So here the Honorable Apex Court goes on to say, this was a 3-judge bench, Honorable Justice Sanjay Kishan Kaul and Honorable Justice Abhay S. Oka, Honorable Justice Vikram Nath, all three fantastic justices, and the lordships. And one of the lordship, the first lordship has recently retired. He was the second in number in the Honorable Supreme Court of India. And this is a fantastic judgment which has fascinated me a lot. This was delivered on the September 15, 2022. Honorable Supreme Court says there is no question of opportunity of hearing in a scenario of this nature, and we say nothing else but that a law as enunciated by the Constitution bench in Iqbal Singh Marwa's case Supra is in line with what was observed in Pritish's case. So these are the two judgments what it has banged upon, and it has interestingly both the judgments in Pritish's case and Constitution bench judgment in Iqbal Singh Marwa's case have not been noted in order passed in the Sharad Pawar case. So this was not a judgment. The Sharad Pawar case was just an order. Order is basically it is basically based on the facts and circumstances of the case, but whereas the judgment deals with the question of law. So the question of the judgment has got, whether reportable or non-reportable, the judgment has got more binding presidential value, and it has to be honored, it has to be respected, it has to be implemented across the country in all the courts across, also in the civil authorities as well, and also each and every person as well. You might not be a party to it, but you're also coming under the umbrella of the Honorable Supreme Court of India by virtue of Articles 141, 142 and 144. The law declared by the Supreme Court of India is binding. Alright, my dear friends, and also there are some more landmark judgments like MC Mehta versus Union of India. This was in the year 2004. Keeping this background in mind, we are of the view that the ends of justice would be served if the contemnor is sentenced to 1 week simple imprisonment along with the cost of rupees 1 lakh. The cost shall be deposited in the registry of this court within 2 weeks from today, and on the cost being deposited, the registry shall pay 50% to Delhi Pollution Board and 50% to the amicus curiae, who is a friend of the court appointed by the Honorable Supreme Court in this particular case. He was also being compensated, provided his remuneration. And the next thing, Balwant Bhai Som Bhai Bandhari. If at all somebody commits a crime of perjury and wants to get away by tendering an apology, unconditional apology, now this Honorable Supreme Court in this particular judgment has categorically stated that the apology tendered should not be accepted as matter of course, and the court is not bound to accept the same. The apology may be unconditional, unqualified and bona fide. Still, if the conduct is serious which has caused damage to the dignity of the institution, the same should not be accepted. That means the court of law, whether it's an Honorable High Court or the Honorable Supreme Court of India, will go ahead with the sentencing and as well as imposing heavy exemplary costs. So one has to be very careful while drafting the affidavits. Okay, whatever, you might be telling the truth, but if you don't have, it's treated as false only at a later stage. So whatever truth you have, whatever evidence you have, based on that, only to state that truth and go. Let it. Truth can be only this small, but it will help you win. If along with that small truth you weave around a big, huge falsehood of web, then it will be, even the whole purpose will be defeated. Your 99% of falsehood will come on the face, and your even 1% of truth will not stand. But if you stand on that 1% truth without the help of any type of falsehood, you will I'm sure that you will be winning the case, my dear friends. And the next thing, I would like to tell you is also you have the Perry Consagra case, which is also a landmark judgment where heavy costs were imposed, and the people have been sentenced as well in another case also. Arish Asghar Qureshi versus Farid Ahmad Qureshi as well. The High Court felt that prima facie case has been made out for perjury under Section 340, and that is, it would be expedient in the interest of justice to prosecute the appellant before us. So you can see how strict this particular perjury is all about. No doubt, giving of false evidence and filing false affidavits is an evil which must be effectively curbed with a strong hand. But to start prosecution for perjury too readily and too frequently without due care and caution on inconclusive and doubtful materials defeats its very purpose. Prosecution should be ordered when it is considered expedient in the interest of justice. And one more thing, my dear friends, like if you go through this Kishore Bhai Gandubai Pitani versus State of Gujarat, the Honorable Supreme Court has said like it's high time, like the witnesses are turning hostile. It's time to take them to the task under Section 340 along with Section 195 of CRPC read with 193 IPC, wherein you will be punished for 7 years of imprisonment. So one should be very careful with all these kind of consequences, my dear friends. I hope it will be of useful information for you. Thank you for your audience.